Welcome to the Smith Publicity All Things Book Marketing Podcast, offering tips, insights, and advice from the best in the publishing industry.
Hello, and welcome to this episode of All Things Book Marketing. I'm your host, Olivia McCoy, and today, super special guest, Joe Perry. Joe is a publishing attorney and literary agent at the law offices of Joseph J. Perry, PC, and Perry Literary. I was saying before the show, I'm super excited to have you on. I know the entire team wanted to interview you. They gave me a list of questions to ask.
Oh, that's great. I'm very happy to be here. Thank you so much.
It's going to be very exciting, but why don't you go ahead, introduce yourself, tell us a little bit more about what you do and how you help authors.
Sure. So as you had mentioned, I'm a publishing attorney and literary agent, and I feel I see both sides of the business from both roles. You know, as an agent, it's really more traditional publishing and, clients wanting to get published at, the biggest houses. Whereas as a publishing attorney, most of my clientele actually are debut authors, people who want to start their own companies. They're, publishing houses or ghostwriting companies or editing companies, whatever it may be. Or people who want to, have a hybrid contract to negotiate, or self-publishing authors. So it's on the completely different side of things. So I'm able to see publishing through, both lenses. So it allows me to give better legal advice and business advice. What I like about both roles is that I can utilize my skills in both of them to help my clients. I'm happy to dive deeper into exactly what I do, but as an intro, that's what I do.
I saw on your website the big things that were listed there was agreements and starting up your own publishing company and reviewing manuscripts. Is that correct?
Yeah. So those are the three things, and registering copyrights. So I draft and negotiate all types of publishing related agreements, from your traditional agreement to your ghostwriting to freelancing to collaboration agreements. I've actually done a lot of them lately, to reviewing manuscripts for copyright issues, trademark issues, libel, right of privacy, registering copyrights. If authors want to do that, that's one of the easier things that authors, I think, can do themselves, but sometimes they want an extra set of eyes on it. Those are really the main things. Oh, and of course, starting companies. I don't do like the LLC aspect of like the business organizations part of it. I mainly help on the publishing side. So drafting, your publisher's, traditional publishing agreement or hybrid publishing agreement or distribution agreement, or work for hire or contributor agreements, whatever you need to run your business. That's what I do, but I don't necessarily help with the forming of the organization, whether you want to choose like a corporation or an LLC.
Well, that's a great way to lead into our first question about agreements. So what is an agreement in the publishing world? Who should they be between? What are some of the points that are typically included? Because I know that's kind of a big question. I know there's a lot of different contracts and agreements, but what are the ones you see most often?
Yeah. So let's start at the very beginning. So if you're a writer and you've written a book, what are the potential agreements that you may need? Well, if you've written it with somebody else, or it's a children's book and it's illustrated by somebody else, you need a collaboration agreement. If it's an anthology, you'll likely need a contributor agreement to make sure that you cross all your T's and dot all your I's in terms of who owns what for the intellectual property. Outside of that, what you'll need is it depends on what you want to do. If you go to a hybrid publisher, you'll need the hybrid agreement to be negotiated. You need a traditional agreement, and they're not really that different from each other. The only difference, I would say, obviously, is the big one is that one you pay them to publish your book, and the other you don't. And there's potential, room for refunds. We can get into the nitty gritty of hybrids, but those are generally the big differences. So it's really like looking at your situation and seeing like, okay, who is helping me write this book? Who's helping me along the way? I forgot to add one, if you want to get your book edited, you'll probably need an editorial agreement, and that the editor hopefully will give you the agreement, and then you could, redline it. But just look at, the whole process. here's the creators, here are the people that are helping me along the way. Whether that's a cover designer, then you need an agreement for that to make sure who owns the copyright, and you're able to actually display the work and do what you need to, display the cover and do what you need to do for that. So just breaking it down step by step, and that's what I try to do with all my clients, just so they can see, like, especially the ones who have started their own publishing house, like, here's everything that you need to do. And it may seem daunting at first, but I'd much rather have that all done, so then there's no questions once the book is published, because you don't want to say, like, oh, you said this or you said that, and now you're reneging on your promise or whatever it may be. So it's just always good to have things in writing, just in general.
So when you say starting their own publishing house, is that like self-published authors who are writing under their own publishing company name, or is that more like a hybrid thing?
It's more of a hybrid thing. I've dealt with it from the self-published angle, but it's more or less someone who wants to start it and publish other authors.
Other authors. Okay. Interesting. And then for contributor agreement, because that was interesting to me, is there like a certain amount of contribution or quotes or something that leads to a contributor, as opposed to like just a quote from someone or a reference to someone? Like, what's the difference between a contributor and someone just referenced? Yeah,
I mean, quotes themselves, well, it all depends on who you're using it, but who's written the quote, and how much is used. If it's just a few words, it may not even be copyrightable. But if it's an entire short story, I'm just thinking like an anthology, like, for instance, like I would say a fully written creative work that's not just a quote, but that is you can call it an essay, a short story, whatever you may be, but whatever it may be. But at the end of the day, like, this is an essay, this is a short story. It's not a quotation. So if quotation is different, you would probably need to get, and I know we're going to talk about this later, but you would need to get permission, or you have to see if it's within the parameters of fair use.
That makes sense. That makes sense. So contracts and agreements are useful for any publishing path. So traditional, I know they usually do traditional. I feel like in hybrid, some bigger indie, more established indie publishers might do like a overarching publishing agreement that kind of covers all the different departments. But then for self-published authors working with like freelance book designer and editors and stuff, you'd still want those individual contracts.
Yes. Oh, and I forgot one big thing: publicity. Of course.
Publicity, of course.
And marketing. Yes, of course. So if you're hiring somebody, I imagine that they're all under the umbrella of freelancers, whether that's an editor, a publicist, cover designer. That's all I can think of at the top of my head. But that's what you would need if you're self-publishing. If you're traditionally, or it's at a hybrid press, usually those things are taken care of. So you probably only need just one big agreement, whether that's with the hybrid press or the traditional press. But it all depends on your path.
The business development team takes care of our contracts, so very grateful for them doing that for us.
Yes.
And then I was actually interested to see one of your services was reviewing manuscripts. So what does that entail? What does that look like to have a literary lawyer review your manuscript?
Yeah. So what I usually do is I review it for certain big issues, and it's really just a handful of issues that really come up, for authors, and that's copyright, whether or not what you've taken is fair use if you haven't asked for permission. Trademark law, although I have to say that is more rare these days. Really, the big one for me is libel and right of privacy, because the vast majority of manuscripts that I review are memoirs. Some of them are narrative nonfiction, but with memoir, it can be a sticky situation depending on what you're writing about, who you're writing about, and there are rules within each state. So what I do, because with libel and right of privacy, there's 50 sets of laws, I really just do a general reading of because you could glean what libel is and what right of privacy is generally, and you could say, okay, this is high risk, this is low risk. It's essentially managing risk, but that's really what I do for the legal reads. And for copyright, that's I'd say that's sort of secondary. It depends on how good you've done already in terms of getting permission, or sourcing your material. If it's all jumbled, then it'll take me more time to figure out, okay, where have you gotten the material? How much did you use? If it's all set in order, then it's much easier for me to determine the fair use. And fair use is actually changing now because of the Warhol case that just came down earlier this summer. I'm happy to talk about that because I think it has a big
please
impact.
do.
So the Andy Warhol case, of course, has to do with visual art, but there are implications for writers and really creators in general. So it was a very specific issue that was before the court. Let me just take a step back really quick to talk about fair use so you can understand what I'm talking about. So for fair use, there are generally 4 factors that courts look at to determine whether your use is fair. The first one, they look at the purpose and character of the use, and they look at whether your use is what is called transformative use. And that's what I'm going to get into in a few minutes here, because that's now changing. The second factor is the nature of the work. Are you taking copyrighted materials that are creative in nature, like a song, a novel, or is it more factual in nature? Is it a database? For instance, notwithstanding any proprietary information, but is it more just factual? And courts give more leeway to creative works, sort of because it's like you're this artistic genius in the eyes of the law, like you've created something out of nothing. So you get more protection. They also protect unpublished works. They want you to be in charge of where you publish your work first. Third, they look at, and this is what I think everybody thinks of when they think of fair use, is how much you've taken, qualitatively and quantitatively. And there's no bright line rule. It's not like, oh, I only took 10% or 20%. It's all context dependent. And qualitatively, meaning you can't take the heart of the work. There was a case way back when about President Ford's memoir, and he was going to have an excerpt in Time. The Nation magazine scooped that excerpt, published it itself, and published, I believe it was 300 words, but it was really all about why Ford pardoned Nixon. So there's really no reason, A, to buy the book, and B, they messed with the licensing market between the copyright owner and Time. So even though it was 300 words, it was still the heart of the work. So the big thing is quantitatively and qualitatively. Just because you take something that's small doesn't mean that it's automatically going to be fair use. Okay. And then number 4 is its effect on the market. Is it a market substitute? Is it direct? Is it indirect? But in terms of those 4, the big one is the first factor. And this is why this case was so important, because it looked at really what the purpose and character of the use is. And it looked at specifically its definition of transformative use. And before this case, essentially all you needed to do was state a new meaning or a new message. Okay, and I'm getting into the weeds here, but copyright law wants you to progress the arts and the sciences. Okay, that's the whole point of it. They don't want you to copy and paste somebody else's work. There has to be a purpose, a reason for you to include somebody else's copyrighted material. So what is that purpose? Okay, before, all you had to do is say, okay, I'm going to recontextualize this copyrighted work. It has a new meaning or new message in my work. Now, what you need to do is also add purpose to that, because that was the big thing that the court was looking at. What is it to have? What does it mean to have, a purpose in your work? And really what they're saying is that you need to justify taking that copyrighted work. The purpose has to be different, and it has to look at, each purpose has to be looked at individually. And the court said, what may be fair use for one purpose may not be fair use for another. So even though it was just a visual arts case, it does have wide implications for writers. So the question is, okay, if I have to justify my purpose, what does that mean? I mean, the good news is not every purpose is the same. So like, for instance, a parody is not the same purpose as the original song. An academic article is not, theoretically, at least, the purpose is not the same as a trade book. So if you were to include that article in your trade book, it's technically different. But this is where we are right now, and this is going to get parsed for years and years to come. So generally speaking, I can say, like, yeah, you have to look at your purpose, but I know going forward, it's going to be parsed year after year after year. So that definition may expand, it may narrow, but it's going to change. But this is where we are right now. So, but anyway, it's a long diatribe, but that's what that was the impact of this case, at least in my opinion.
That's so interesting. I actually hadn't heard of that case. I guess I don't deal a whole lot with the legal side.
It was just before the Supreme Court. Yeah.
So how does that affect excerpts then when we're using excerpts in marketing and promotion and things like that? And I know excerpts are generally in some kind of publisher agreement, who owns the rights and who gives permission for how much can be excerpted. I know some distribution sites like Amazon for like their look inside will take an automatic 10 to 20% of the novel and have that be available. And I know it's generally random, but it's generally like the first part of the book and the bigger chunks missing as you go through. You don't have any control over that with Amazon, but what about for your own authors promoting?
Right. Yeah. So what I usually, in terms of fair use, usually those things are contracted, so it's a license, so it doesn't necessarily affect it as much. That was really more or less, there's no licensing agreement, and you're trying to figure out, can I use this? Can I not use it? So if it's a licensing agreement, it's usually, that it's whatever it's in the agreement. But what I try to do, no matter what the agreement is, this goes really more towards the non-compete section, because the competitive, work section, that will say, you're not supposed to do anything that's going to interfere with the the sales of the work. And the question always comes down to, okay, well, what about articles that I read or want to write? What about excerpts? Usually publishers are okay with excerpts because that's obviously promoting the book. So what I try to do is put like a hard word count on it, depending on how long the book is. So if it's like 80,000, 90,000 words, we could say, up to, 3,500, 5,000 words. Something along those lines. They're just made up numbers. It could be whatever it is. But in terms of generally speaking, writing other articles, it gets into another issue. But it's, as you can see, it's all interrelated. So outside of the excerpts, if you just want to write articles, then you need to carve out language that allows you to do that. Essentially, the publisher doesn't want you to take the exact wording that's in your book. So if you can write about the subject, but write about it in your own words, that's fine. And this happens a lot for nonfiction authors, because you've written a book on whatever topic it is. It's not like you're never going to speak or write about that topic ever again. So you just want to make sure that you're able to do that, and that's why you want to carve out that language.
Yeah, that makes sense. For permissions, what does permissions look like? Is that like we had like a thumbs up emoji over text, like, can I quote you in this thing? And they send it like, does that count? What is that?
Right. You really need to get it in writing, and it all depends. If you email people and they say, yeah, sure. I look at it from a practical perspective as well. Yes, you want to have this big licensing agreement, permissions agreement, but sometimes that scares people. So sometimes the best thing is to say, hey, can I write this? But just have it in writing. Here's what I'm doing. Here's where it's going to be published. Can I, use that, material? And that's, good for average everyday people. However, when it becomes to more sophisticated actors, companies and, people who know how to sort of take advantage of permissions fees, that's when you'll need to really be detailed in terms of how you're using it. They're going to have a ton of questions for you. For instance, what territory is it going to be published in? What's the print run of your book? In what way is this going to be used? Et cetera, et cetera, et cetera. And sometimes the copyright owner will have their own agreement and they'll send it to you. A lot of times you have to email them and tell them all this information. Like I just said, like part of that information, there's other things you need to put in there. And then that gets the conversation going. And then that leads to the question of, okay, they come back to you, is it too expensive? Which happens all the time to my writers, because, sometimes they say, yeah, sure, you can use it, but here's $10,000. And they're like, I don't want to pay $10,000 or $5,000 or whatever it is. Or you just never hear from them. So like, what do you do? And that's where fair use comes in. So that's why that case was so important going forward. So
I think one of the examples that was mentioned was Ready Player One. That was a book that has like a ton of pop culture, popular references. So we're trying to figure out how expensive was this book, first of all, to make, and how referencing something that maybe like someone said, but then was taken and used in a wider context, like on social media, like a popular hashtag or something like that. Is that fair use, or you had to get permission for that?
All depends. I imagine there was permission for some of the things. But I can't speak to that. But I would assume that they wanted to that the publisher asked them to get permission, just because that is within every contract. Now it depends on what the lawyer said, and I haven't read it, so that's why I'm saying I can't.
Yeah.
I know of it, so I can't speak for what they did, but I imagine they asked him to get permission for a lot of things. However, it depends on how he uses it. Recontextualize. Now it might be different because now it's a different purpose. So it's that added layer that you have to add on to it. But new meaning, new message. Have you taken a lot? How much have you taken? Is it a market substitute? That's really what they're worrying about within that last factor. Are you killing off a licensing market for the copyright owner? Would they have done this, but not for you? Your book? Would they want to come out with their own? That sort of thing. So there's all these things that are interwoven into each other. So that's why I would imagine, rather than going through that dance of and going through that huge argument of is it not, I imagine they asked them for permission. So anyway, that was a long
probably point. Safer, better safe than sorry. Just get the permission.
Yeah. I think so too.
Random question, because you mentioned memoirs earlier. I never understood how it worked if they changed the names, changed some details to protect someone's privacy, but then they still refer to them as like my aunt. Maybe say my Aunt Jane Doe, and Jane Doe is obviously a fake name, but aunt is still, people could figure that out. How does it work with memoirs?
Right. Well, I guess there are two things to look at. If you're the author, it's really the two things what I mean is the author and the reader. And as the author, what you want to try to do, especially if it's very sensitive, is try to create a composite character, change genders, change names, change characteristics, change geographic locations, basically change everything about it. The con of that is if that person knows it's them, no matter how you describe them, they know. So the question becomes, from the reader's perspective, it's really a reasonable reader standard. Is this author libeling me? Are they violating my right of privacy? So what is an author to do? Well, that's when you want to sort of potentially be a little bit more conservative. And I always ask, is that specific passage, is that essential to telling your book? Do you absolutely positively need it? Because what are the chances of that person coming after you? Most people, I would argue, probably are not, just because of the amount of time, the amount of money it takes to file a lawsuit. Now, for the people who have the money and the time, that's another thing. And so if you're dealing with somebody like that, that's when you want to be really conservative and potentially take the passage out. So it's really all one big risk analysis in terms of who you're writing about, what you're writing about. So the more positive it is, the generally the less risky it is. But of course, if it gets into someone's private life and they don't want those things out there, that could be a potential issue. I don't want to get into the weeds of privacy laws, but it really just comes down to essentially, I think, following your gut sometimes. Like, okay, I know this person. Are they going to come after me? And the other thing too is that you can try to get a release form. Now the question is, will they actually sign it? So you can tell them, essentially get an agreement, and here's another form of an agreement. It basically says you're going to release me from all claims against you, including you in this book. Some people are okay with signing that, others don't want to. So again, that's another risk analysis. That's what I really look at within manuscript reviews when it comes down to this. Like, how do I minimize your risk, and what do we need to do to because you can't insulate yourself from lawsuits 100%. That's obviously impossible. But what can you do to minimize your risk? And
I feel like it gets into this really touchy topic, especially with memoir authors or people trying to write about their personal experiences. Like, if you start fictionalizing, changing genders and names and situations, any identifying aspects, how much of it is the truth and how much of it is now fictionalized? And I feel like, I mean, I don't know that there's a one answer for that, but I generally am of the belief that as long as your experience is true, the way it impacted you, the way you felt about it, and that's the way you're writing about it, the other details don't make a difference. It's really how it impacted you.
Exactly. And that's part of what I deal with, because authors, like you said, they want to write authentically, and they're like, I don't want to, make this up. But it depends on, what you've written and how much you think someone is actually willing to bring legal action, against you. And, there's also the truth, uh, for libel, truth is a defense. Part of right of privacy for like portraying something in a false light, truth is defense. But for the other aspect, one of the other aspects of right of privacy is essentially publicizing private facts about somebody. And I don't want to get into the details of it. I know we're throwing here for intro purposes, but for that, even if it is true, you could still be sued for that, depending on what you've written about. Like for instance, if there sexual activity, drug use, alcohol use, all those, sort of nefarious things that, people think of. It depends on what it depends on the state law. So anyway, I say that because people say, oh, well, it's true. Well, that's good for some things, but other things it could still hurt you. So that's where, you just want to look at that passage and see like, okay, do I really, really, really need this? And how likely is it that I think this person is going to come around and sue me?
Before we wrap up, I have a couple more questions. I feel like we can't not talk about AI. It's such a hot topic, and I know everyone's getting into it, but with AI now, ChatGPT helping people write, we have AI art now, so cover designs by AI. How does that impact literary legal world?
Yeah, so I actually had somebody reach out to me about this, and right now there was guidance, at least as of a few months ago, from the Copyright Office, which essentially said that any authored, like human authored material is copyrighted, but anything that is not copyrightable. So if you're on ChatGPT and you're writing in your prompts, and all you've done is essentially collect the information from those prompts and turn it into a book, you're likely not going to get it copyrighted. You then have to take your own creativity and do things with it. And I think it has to be above minimum like arrangements and selections, but actually like physically going in and like doing things to it. Again, there hasn't been any cases, at least to my knowledge, yet. So I say that with a grain of salt, things could change. But just know that, they always want that human element to things. So the more you do with that book that you've created with AI, the more, at least in my opinion, the more likely it is to be copyrighted when you register it. And you want to register your copyright in all of your books because you want to be able to enforce your rights and get statutory damages. If you don't register it, you can't get those statutory damages. So what does this leave, where does this leave authors? Okay, so that's creating in terms of where it leaves authors, but what about using third-party materials and things of that nature? Well, if you go on the Authors Guild website, they have provisions to put in your contracts to protect your works. And to make sure that the publisher isn't using AI and generating anything for your book, whether that's editing or cover design or whatever it may be. And I know that outside of the traditional publishing, self-publishing, like you had just mentioned, there's been AI created cover art, but I know that's what is happening, at least at the Authors Guild. So.
All right, interesting. I do feel like currently I'm seeing a lot of articles that are more like, I put this into ChatGPT and I'm just publishing the exact conversation or doing that. And so I know that there are books coming if there hasn't already been one created. I'm sure that there have. I just haven't seen them yet.
Yeah,
so I'm sure that will be a case that comes up.
Yes.
Soon. We'll have to do a part 2 or something.
Yeah.
When that case happens, would love to get your perspective on that. But that's going to be really interesting. And then the title of the podcast is going to be What Literary Lawyer Wants You to Know. So what is your number one piece of advice? What do you really want authors to know?
I would love authors to know about, I'm just trying to think of there's a way that you can learn more about, well, I offer this, but I give webinars all the time to authors. But I think what will really, really help you is understanding, or at least trying to understand the basics of copyright law. I understand that you're not a lawyer, but it's going to affect how you're able to use material, what you're able to do, because I can't tell you how many times I've been in a situation where someone says, I have a great idea for a book, excuse me, and I'm going to write it, and then they realize all the things that they may not be able to do that they thought they were going to be able to do in the first place in terms of writing, in terms of getting permissions. I just think a lot of authors are kind of amazed in terms of everything, like the back end of things and sort of the administrative aspect of it. Register your copyrights. I tell everyone, please, please, please do that. It's simple to do. You can go on the copyright.gov. And also, if there's a way, start, learning more about, contracts. I guess generally my advice would be try to know the business of writing. I feel bad for authors because I feel like all everyone tells you to do is increase your platform, know your craft, which obviously you should as a writer. But I feel those two things are above everything else. So I feel people believe they're never going to get a deal unless those two things are at the top, and which is partly true. But there's also the business side of things that once you get over that hump, or you get your self-published deal or your hybrid deal, whatever it may be, you have a contract to look at. If you don't know what you're signing, you don't want to, give away your rights or sign a contract where you're not able to terminate it for X amount of years. So, start knowing the business. You're an author, and part of that is a business, knowing the business, excuse me. So I just say you're in a business for yourself, right? So, know your craft, know what you have to do to engage your audience, and also know what to do to protect yourself. So anyway, that was long-winded, but
no, that's perfect answer. And authors can educate themselves, learn more by going to and following you on.
Yes. So for my law firm, you can go to josephperrylaw.com. I have blogs I try to update all the time in terms of giving author tips. I give free webinars. I actually have one next week coming up.
What day next week? Because this is actually going to be published Tuesday.
Yes, July 15th. You can register for it on Twitter. I'm at PerryLaw1. And I'm going to be advertising it as the coming day in the coming days. But yeah, I give free webinars that go over book contracts, intellectual property, First Amendment issues, right of privacy issues. It's usually about an hour and a half. Then it's open for Q&A, and I've given webinars to all different types of organizations and writers groups. And you can follow me on social media, like I said, on Twitter, and then on Instagram, I'm at Joseph Perry Law. For my literary agency, that's called Perry Literary. For anybody who's interested, I'm a nonfiction agent. I've had over about 40 deals now so far in the last, I'd say, 5 years. I had my first bestseller a couple years ago.
Exciting.
The Unofficial Disney Parks Cookbook. Nobody can go anywhere, so it was the best way to cook food from Disney, and that took off like a rocket. It ended up being a Wall Street Journal bestseller, USA Today bestseller. Sold over 500,000 copies, and that spawned its own series. So I've brokered, big 5 deals to university press deals as an agent. So I bring that up because from both sides of the business, I'm able to, like I mentioned earlier, give legal and business advice based on my experiences there. So if any authors are out there who want to be traditionally published, please feel free to email me at jperry@perryliterary.com, or you can go to my website and you can, submit, a query to me there.
Perfect. We actually have an upcoming podcast about the bestseller list. So
cool.
Keep an eye out for that one. But
yes, definitely.
Thank you for your time. I really appreciate you coming and educating us today.
Of course. Thank you so much for having me. I really appreciate it.
Thank you for listening to All Things Book Marketing. If you enjoyed this episode, please rate, review, subscribe, and send it to anybody else that might be interested. We'll see you next time. Thank you for listening to this episode of the Smith Publicity All Things Book Marketing Podcast. To reach us and learn about our many services, visit smithpublicity.com or send us an email to info@smithpublicity.com.